The UDRP, or Uniform Domain Name Dispute Resolution Policy, may be the best and most popular way for trademark owners to fight cyber squatters, but it's not the only option. In fact, a domain name dispute filed by a large law firm on its own behalf provides a good lesson about the pros and cons of going to court instead of filing a UDRP complaint. So the case involves Debevoise Plimpton, which is a New York-based law firm with about 800 attorneys in 9 offices across 3 continents. In October 2021, the firm found itself to be the victim of a cyber squatter. So while the firm uses the domain name debevoise.com, a cyber squatter was using the domain names debevoise-law.com and debevoise-laws.com, which were registered in September and October 2021. According to a magistrate judge's report in a lawsuit filed by Debevoise, one of the domain names was being used in connection with a landing page filled with ads for legal services, while the other domain name was used to send phishing emails imitating a partner at the firm. And not surprisingly, one of the emails included in the complaint was riddled with typos, although perhaps they were easy to overlook. Unfortunately, as I discussed in a video earlier this year, law firms are not immune from being the targets of cyber squatters. And in fact, I've seen an increasing number of UDRP complaints filed by law firms on their own behalf, sometimes in cases in which the disputed domain names were being used to impersonate the firms as part of an effort to solicit payment for falsified invoices. These so-called business email compromise scams are becoming quite popular. And I have personally filed 9 UDRP complaints that fit this scenario just in the past 2 weeks. But in the Debevoise case, the law firm did not file a UDRP complaint, and instead, it chose to file a lawsuit in U.S. District Court for the Eastern District of Virginia under the ACPA, which is the Anti-Cybersquatting Consumer Protection Act. The ACPA was enacted in 1999, which is the very same year that the first UDRP complaint was filed, which means that both legal tools, the ACPA and the UDRP, have been available to trademark owners for about the same amount of time. But while the UDRP has become the weapon of choice with tens of thousands of decisions filed, ACPA complaints remain relatively rare. And that's because the UDRP was designed to be a quicker and less expensive alternative to litigation. But the UDRP is not without some limitations. And one of those limitations is that unlike disputes filed in court, the UDRP does not offer a trademark owner the ability to obtain injunctive relief. That's an interim legal ruling before the case is fully resolved. And I suspect that's why Debevoise chose to file a complaint in court under the ACPA rather than under the UDRP. And on the one hand, the law firm's decision seems to make a lot of sense. And by the way, I know the Debevoise attorney who filed the complaint. He's a leading voice in this area of the law, and we serve together as panelists at WIPO, the World Intellectual Property Organization, as well as at other UDRP service providers. So I would never question his decision-making, and obviously he knows more about this case than I do. In any event, I suspect the firm's decision to file an ACPA complaint was motivated in large part by the availability of injunctive relief. According to the magistrate judge's report, Debevoise filed its complaint on December 13th, 2021, and a U.S. District Court judge issued a preliminary injunction effectively transferring the 2 disputed domain names to the firm just 3 days later. Now, when compared with the typical 2-month time frame required for decisions in UDRP cases, that obviously sounds incredibly quick. But there are a number of issues that are worthy of consideration here. First, most trademark owners are not large multinational law firms with attorneys who can file a complaint in federal court and pursue it on their own. And even hiring a large multinational law firm is not something that every trademark owner, even some of the biggest brands, is prepared to do when it comes to domain name disputes. And no matter what law firm or attorney is handling the case, an ACPA or a traditional trademark suit in court can quickly become an expensive process, something that the UDRP was created in part to avoid. Second, the Debevoise ACPA complaint was based on what's called InRem Jurisdiction, because the real identity of the domain name registrant was concealed by what the court described as an Iceland-based privacy service. InRem complaints for .com domain names under this ACPA must be filed in district court for the Eastern District of Virginia, as Debevoise did, because the registry operator for all .com domain names, VeriSign, is based in Reston, Virginia. That's usually not convenient or practical for most trademark owners. On the other hand, UDRP complaints can be filed with any of the 6 ICANN-approved UDRP service providers, and in any event, UDRP complaints are filed electronically, and they don't require any in-person appearances, making them incredibly more convenient and efficient. Third, although Debevoise quickly obtained injunctive relief under the ACPA, the entire case took much longer to resolve than any UDRP proceeding. After it obtained a preliminary injunction within a matter of days, Debevoise had to wait more than 8 months, about 4 times as long as a UDRP case would take, to receive the final judgment. And along the way, Debevoise did receive some media attention for its case in the mainstream and legal press, as well as on some of the blogs for domainers. And a Reuters reporter who wrote about the final judgment contacted me for comment. As I told her, most trademark owners choose the UDRP because cases are typically resolved quickly and efficiently, often in just 60 days, as opposed to the 259 days that it took to resolve the Debevoise case under the ACPA. So, the bottom line is that while ACPA or trademark complaints in federal court may be appropriate for some trademark owners, the UDRP really remains the best option in most cases because it is quick, inexpensive, and relatively simple. If you want to learn more about the UDRP, please check out my masterclass on domain name disputes, as well as other resources on my GigaLaw website. And be sure to subscribe to the GigaLaw YouTube channel to be notified of future videos discussing other internet legal issues. Thanks for watching, and see you next time online.